We'd like to welcome all of you in attendance to our webinar dealing with corporate reorganizations, estate freezes, the use of trusts in various different contexts. And today we have two special guests who I will introduce momentarily that will be speaking to you about the impact of family law and estate law implications, which are very often overlooked in the tax planning arsenal. In fact, my guests here do not require an introduction, but I'll introduce them anyway. We have, first of all, Ian Hall of Hall & Hall, partner there. Ian is known across Canada and abroad for his expertise in estate law, author of many publications, as well as members of various different groups and recipients of some very prestigious awards. So welcome, Ian, and thank you very much for joining our program today.
Thanks. I'm proud to be here.
Great. Also, I'd like to introduce Allison Pengelly. And of course, Allison is a family lawyer that brings a tremendous amount of creativity to her approach to family law. I've had the good experience of working with Allison on various different client matters for, I think, a few years. And we've always found Allison to be, first of all, very effective with helping individuals to identify specific problems and then to seek a resolution. Allison is also involved in the tax arena. She's, I believe, currently taking her master's of tax and is incorporated taxation into family law, which I believe gives her a very good edge and advantage, I'd say, in many of the matters that she's represented. So, Allison, thank you for joining as well.
Thanks. A privilege and a pleasure, Todd.
So when we discussed this program, we initially contemplated exactly what are the issues, and there were just so many. The list was so exhaustive. We said, well, we can't really possibly even approach these issues, over the course of a 1-hour program. So it ended up that we narrowed this down, and one of the big issues that come up, we see a lot, is we see corporate structures where there's an entire absence of I'd say, understanding, or perhaps not understanding, but consideration of these family law and estate law issues. And of course, one of the ones that just comes to mind right out of the gate for me is whether or not both spouses should automatically be shareholders of a company. And of course, we see it all the time, and you lawyers and attendants, the corporate lawyers and so on, and accountants who are involved in giving advice as to who shareholders should be and why. Just like you to consider the following: despite the fact that the Family Law Act provides for an equalization of net family property, there may be some other issues that come about if both spouses end up in a dispute and end up as shareholders. So maybe, Allison, I'd ask you to kick off and just say, how can that type of a scenario be worsened? Obviously, it's bad enough when a marriage breaks down, but then all of a sudden, what other issue do you have?
So for out of the gate, most important thing is to have a shareholders agreement in place. But often in that scenario, that doesn't happen, and that's what creates a lot of the problem. So if parties separate, and let's say the owner, the active spouse in the corporation, owns the majority share interest, wife or husband, depending, has a minority share interest, the other spouse, one could be dealing with an oppression claim. And Todd, you and I have seen that happen on a couple of occasions, actually, when we've been working on a team together. And that can that type of circumstance can pose several problems. The first is the dealing with that oppression claim, the active spouse in the corporation walking on eggshells so as not to be seen as oppressing the other spouse as a minority shareholder. And then, of course, you've got the problem of valuing the minority share interest.
Yeah, thank you, Allison. I think that's very, very important. Not only do you have a marital dispute, but you have a shareholder dispute as well. And Then you have situations oftentimes where a spouse remains working in a company and suddenly she can't or he can't work there anymore because of the stress between the two individuals. And then you actually could end up with a shareholder oppression matter, just like Allison said. And that's a very powerful tool in the hands of a minority shareholder. So it's a one issue, one complication that I think you could probably do without. So please take that into consideration when you're advising clients as to who the shareholders should be. Let's go a little bit further now. Let's talk a little bit more, Ian, in your world, where you have, an estate issue. You have the death of, say, business owners and so on, and you end up with individual shareholders who don't know who's in charge in a company, and they don't know because it was never provided for them. Why? Because there's certain things missing. Maybe there's no shareholder agreement. Maybe there's no succession planning. What is your view of how we could mitigate those problems?
Sure, and I think it's the starting point too is that it's interesting. And Allison makes such a good point about how things can unfold in her world. When we're doing estate planning, there's two things that always amazes me and that are tied to corporate planning. I mean, is that often the tax issues tend to drive the conclusions, the legal conclusions, and the structures. And what happens is, of course, they'll throw in spouses into the mix at levels that maybe haven't been totally considered. The bottom line is the founder or the leader of the asset, so to speak, is he or she is giving up control. And when you give up control, you bring up risk of complaints and so on. But you also, by giving up control, you have ongoing obligations of disclosure. And often in the creation of these plans, the disclosure isn't considered. So one way to help alleviate the techniques of that will ultimately end up in trouble with you in an estate plan is to create some sort of mechanism of disclosure at the outset, some transparency to those who are involved, so that there aren't surprises, and that you haven't been a hidden beneficiary, you haven't been a beneficiary of a trust for 30 years and never heard about it, that sort of stuff. Those are things that only create suspicion, and the more suspicion you have, in light of the fact that you've given up control, creates more problems.
Wow, and just, Todd, if I might, piggybacking off of what Ian just said about disclosure, in the family law sphere, it's very much about full and complete financial disclosure being exchanged at the outset before agreements are entered into. One can negotiate as creatively as they want to once the full and complete disclosure is exchanged. But very important, in fact, there's a section 56 in the Family Law Act, that sets out ways that a party to a domestic contract can attempt to set it aside. And one of them is if significant assets have not been disclosed.
Mm-hmm. I'm just looking through the attendees, and I'm not sure who's lawyers and who's accountants. I know there's business owners there as well, and some consultants and planners and things like that. But I'll say as follows, that just to hitchhike a little bit on Ian's comment about not disclosing who a beneficiary is. Well, we know that there's new trust reporting rules that at least the accountants know that. And of course, all the OECD countries around the world, they're all subject to the same. And, tax reporting, CRA is being used, I guess, to gather information, as it were, right? Which may or may not be a privacy issue. It's a different subject completely. But nonetheless, it's been the desire of most people that we've worked with over the last few decades to be secretive about who constitutes the beneficiaries in the trust. And there are situations where it's more open book, but there is no requirement to disclose who a beneficiary is to that person. You can name anyone you want. And Ian, you've just pointed out that failure to divulge that, but I think going further, failure to communicate. Previously in discussion, you were mentioning a rationale as to why an individual may inherit a certain part of the estate and another one may not. You have 10 beneficiaries of a trust, maybe more, because it could be grandchildren, nephews, and nieces, fully discretionary trust, no automatic entitlement whatsoever to those beneficiaries. how would you extend that? Beyond saying, divulge it, but what do you do next? How do you make them aware of what their perceived entitlement ought to be?
Yeah, well, and it really does depend on the nature of the assets and so on. But often what I'm encouraging my clients more and more to do is to think about a family meeting and to have some sort of, either it can be at the dining room table or it can be right through to a hybrid of that would be, sort of an organized, facilitated meeting with the advisors, bringing people around the table, bringing in generations, bringing in the hard sell piece of it too. And that is, of course, the possibility of bringing in spouses and how to bring in spouses. Because, of course, we've all know that the pillow talk is a big problem with this, with all of these planning problems. And that is that who's not in the room and what are they saying? So I try to get my families in those situations to actually engage in a direct, organized, with an agenda, professionally established, try to do it offsite if you can, kind of meetings where you're bringing in the full-on disclosure so that truthfully, I mean, look, there are, and we all know there are families that have passed on wealth enormously successfully, and there are those that do not. And now there's a lot of factors that can come into that, but one of the factors where the successful families pass on the wealth is as a consequence of the fact that they're stewards of the wealth, and that they're managing it as professionally and as transparently as is applicable to their circumstances.
Yeah, and I'm going to take that a step further. I'm going to say, despite the best efforts, we see some very high-profile families over the decades who have run into problems. We've seen what happened to Canadian Tire about, I don't know, is it 30 years ago, maybe? I'm dating myself. Yeah. We see Magna, right? We see Rogers, So we see all of these situations, right? And of course, whether we're dealing with dual classes of shares or whether we're dealing with a family trust where there's a chairman of the trust which actually controls these assets, and we have other family members, we have people replacing board members, we have corporate governance, we have a potential nightmare that can take place in any company whatsoever. But it puts us as I'm just going to take a step back from the conversation for a minute and say, it puts us in a very precarious position because there is no right and wrong answers, I don't think. What there is a fundamental need to ensure that the business owners, the entrepreneurs, the shareholders are aware. I have seen too many times, I don't know about my colleagues here, but I've seen too many times where we see very successful, very accomplished, sophisticated business people that say, here's a diagram of my corporate structure. Don't ask me what it means. Talk to my lawyer accountant. Wrong answer. So that's what they want, but you got to bring them back.
That's right. And that's where it starts. Really does. It starts with the head or the heads of the family to send that leadership tone out and to create. I mean, you don't need to have Rogers or Canadian Tire wealth to manage this. Significant enough wealth that you want to, as I say, you want to be stewards of the wealth and you want to be able to pass it down. It comes down to even as granular as buying an RESP for your grandchildren. I mean, that is part of stewarding your wealth, making sure that the next generation understands what you're doing, having that discussion, not just getting the kudos for doing it, but having the presence of mind of saying, this is important.
Yeah. So I think that our message then is really the family heads need to be, the parents, shareholders, they need to be in the discussion. They can't just, and your accountant and lawyer do not know better. I'm sorry, but they don't. Family dynamics are unique. There's sensitivities. There's things that only you can do, and that none of your advisors will be able to help you with. So understanding your corporate structure is only the first step, and then understanding what your options are is what comes next. Ultimately, it's what's important to you that needs to be put forward. If you're not involved in the planning, your priorities are being, in effect, set aside and not even considered, other than the perception of your priorities from your lawyer and your accountant, which may or may not be correct, may not be accurate, may not reflect your genuine priorities.
Yeah, and as advisors, we all, and I know Allison does this too, like we have this obligation not just to do the work, but to explain the work in plain English, in a visual way, in a graphic way, maybe if necessary, so that our clients understand the concept. They don't have to have the granular understanding of every term of a shareholders agreement, but what the shareholders agreement does, what does a separation agreement do, what does a marriage contract really do, and those kinds of sort of summary, plain English teaching is so important. And what we get caught up in as professionals is we get caught up on making the work product, and we sometimes forget that our clients at the first stage have to understand it, because they're going to be the ones who will want to pass that information on in their own words.
Great. I'd like to talk about trust now. I believe that, trusts are an important part of life for everyone. And what do I mean by that? Does everyone have a family trust? Is everyone affected by a testamentary trust created by a will? Well, maybe not. But trusts are something that we do every single day in life. A trust is an arrangement between family members in context of what we're talking about today. And if you think about, mailing a letter, you address the envelope, you put it in the mailbox. Canada Post is not the beneficial owner of that envelope. That's someone else. Every time you mail a letter, every time you open a bank account, you enter into a trust arrangement. So my first advice is, please do not look at trusts as something that's irrelevant, either because it's exotic, whether it's because you don't understand it, or for any other purpose whatsoever. Trusts are something that I believe will affect everyone in attendance when it comes to estate planning and corporate planning, tax planning, succession planning. There's something that really needs to be taken into consideration. So, of course, when we die, our wills create testamentary trust that can be used in order to provide for distribution of assets. When we're alive, we have what's called an inter vivos trust, which, as you all know, or most of you know, is a trust for the living and essentially benefits you during your family during the time you're alive, is the fundamental difference. Now, there are really a couple of different things I want to talk about here, but one of the issues, first of all, is if you're doing planning that involves a trust. I have a question for the two guests here. One, are the assets going to be, I'm going to say, in a safe, sanctified instrument, or is there any risk of the assets in the trust being disrupted? First of all, in the context of let's just say that we have a son-in-law who comes to work in a company, and his daughter has shares, but he doesn't. What might happen in event of a marital dispute? Say they split up, and the spouse does not own shares directly, but has an interest in a trust as a beneficiary. Allison, I'm asking you.
Sure. So if the question is, will the courts break a family trust? If that's what we're getting at, and how will that interest, not the actual property itself, but it's the interest in the trust that we're focusing in on, how that would be dealt with by the family court. So let's start with, will the courts break a family trust to provide an equitable distribution of that family property? Not likely. Very limited circumstances where they'll actually break a family trust, and typically only when one spouse has full control. So let's say where the spouse is the sole trustee, has the right to distribute to herself or himself. So not sure if the case study, Todd, was sent around to the attendees, but there was a case study about Bill and Carol, and while they're living, the trust continues to be fully discretionary until they're gone. So the court, in that instance, certainly not likely to break the family trust. If it's a totally discretionary trust, no judge is going to order a trustee to give the shares to Ethan and leave the other siblings, the other beneficiaries out. Ethan has no guarantee of getting anything, at least while his parents are alive. The question of actually, we need to next look at the very broad definition of Section 4, Sub 1 of the Family Law Act, which includes any interest, present or future, vested or contingent in real or personal property, and includes property over which a spouse has, alone or in conjunction with another person, a power of appointment exercisable in favor of himself or herself. So very broad definition now of property under Section 4, Sub 1 of the Family Law Act. And the courts thus have had little difficulty in concluding that trust interests constitute property for family law purposes. And then that takes us to the complication of how do you value such an interest, and that's a whole other kettle of fish to include it, as Ian said earlier on, in a spouse's net family property for the purposes of equalization of net family properties. So again, typically a court cannot order trustees to make a capital distribution from a trust to one of several beneficiaries in order to satisfy the equalization payment. And the court, in terms of, again, in terms of finding that an interest in a trust constitutes property pursuant to the Family Law Act, will look at the level of control, whether a spouse has treated the trust asset as his or her own, whether the spouse benefited or benefits from the trust assets, and other things as well. The one important note is income or capital can be paid by the trustee to specific beneficiaries, where that's the case, to the exclusion of other beneficiaries. That can be useful to assert that the assets in the trust do not belong to that spouse specifically. I'm going to move on to a little bit of case law that I think everybody might find interesting.
Hold the case law just for a moment.
Sure.
We'll come back to you and have you share the cases. But before we do, I would like a synopsis from you, Ian, please, if you wouldn't mind, in context of the state law, the death of say parents, and then we have this discretionary trust, and individuals have reason to believe they have an entitlement.
Certain. So I guess, I mean, your question at the heart of it, of course, is there disruption available to attack trusts? And Allison's going through it in the marital breakdown situation. And I can say, after death, again, trusts are vulnerable. And it comes down to good drafting. We all went to, well, those of us who went to law school learned about the 3 certainties. There's certain expectations a trust structure has to have maintained or preserved. It can be attacked in Allison's world more than ours as a sham. It can be wound up under the Variations of Trusts Act. So a trust structure, it's funny, and you would see it in your situations where an estate freezes, where they bring trusts in and so forth, and creation of trusts on an inter vivos level. People think trusts are unassailable, and they are assailable in a marriage breakdown, and they are vulnerable on death as well. So I say that just as a general observation, because that comes back to my earlier point is that the more the beneficiaries know about the trust, the better the trust is led by good, supportive trustees who are knowledgeable and are fair-minded. Those are things that help dissuade attacks. Anything can be, I mean, I always say to my clients, anything can be litigated over. If someone wants to pay someone some money, they're going to litigate, they can say anything. But where you're going to find success or failure with those kinds of attacks is one thing. But if you've created structures where you've meaningfully thought about who's going to be the leadership and meaningfully disclosed to the beneficiaries what their role is, what they're available, what's available to them, what's not available, what restrictions exist, all of that kind of discussion all goes to, truthfully, from a practical standpoint, sustaining trust structures.
Excellent, excellent. Allison, let's hear about the case law that you would like to discuss, please.
Sure, I thought this might be helpful to everybody. A lot of us are already familiar with the first case after the broadening of the definition of property in the Family Law Act to address the effect of that definition in the context of trust, and that is Black and Black, where the Superior Court confirmed that an interest in a trust may sometimes be considered an asset for the purposes of equalization. Justice Walsh of the Ontario High Court of Justice stated, and I quote, "The definition of property contained in Section 4 of the Act is all-encompassing. It specifically and therefore intentionally includes not only a vested, but also contingent, not only a present, but also a future interest in real or personal property. It therefore, in my view, includes the shares the husband received under the terms of the grandparents' wills as property owned as of the date of marriage." Before I go on, I don't want to forget this, a really important point in terms of timing. If one is wanting to gift an interest in a trust to an adult child or children, with my family law hat on, I can't say this loud enough, that would be after that adult child enters into a marriage, because then that gift will be excluded should that adult child separate from her or his spouse. So very important in terms of timing. Moving on, then in cases after Black and Black involving trusts, the courts in Ontario have followed a similarly expansive interpretation of property. The Ontario Court of Appeal in Brinkos and Brinkos held that a spouse's right to a future income stream that's not dependent on personal service was property as defined in the Family Law Act. So we know that also certain future income streams, for example, from a pension, that is property, falls under the FLA definition of property, and likewise do both a capital and income trust interest, which may constitute property for the purposes of equalization of net family property should spouses separate. In DaCosta, the Ontario Court of Appeal relied on the reasoning of Black and Brinkos to uphold the trial judge's decision that Mr. DaCosta's contingent interest in the capital of his great-grandfather's estate constituted property for the purpose of Section 4 sub 1 of the Family Law Act. Then we have the Court of Appeal in Spencer and Riesberry, where they upheld the trial judge's finding that while Ms. Spencer's contingent interest in a family trust that held real estate was an asset for the purposes of the FLA, she did not have a specific legal interest in any piece of trust property. So again, it's the interest in the trust, not the actual property itself. So again, whether or not property held in a trust falls under the FLA definition of property has much to do with the level of control that a beneficiary has with regard to property, with regard to the trust, sorry.
Thank you. I'll just take a minute maybe and just add to what's being said here. So in other words, I believe that it's fairly clear that there's a certain vulnerability and perhaps a false sense of security that people think, just to echo Ian's words, Ian, I believe that you mentioned that there was, you suggested an illusion of some sort. I think that's accurate and for a couple of other reasons as well. And, you know, there's obviously provincial legislation that exists in every province in Canada and elsewhere as well that's known as the Fraudulent Conveyances Act, which has the effect that if an individual is attempting to hinder, to delay, or defraud a creditor, then a court can make an award that can have the effect of attaching these assets rather. And I think that's a concern. There's also a case that we've mentioned before, and that is quite an old case. It's called Ottawa Wine Vaults versus McGuire. And this is a case where a tavern owner had set up his business and things weren't going very well after a short period of time, and he decided to transfer assets out to a spouse. Well, of course, the Supreme Court of Canada rendered a decision that causes us a great deal of concern. in this matter, even though it's an old case. It's been cited several times by the Court of Appeal. And essentially what it states is that McGuire needed not only to consider his existing creditors, but he ought to have considered his future creditors. So there's different kinds of creditors. We have external creditors, could be a supplier, could be an employee of a company, could be anyone else, could be the government, CRA. We also have family creditors, or what you might call internal creditors. And to the extent that the eventuality of death, and many people don't like to talk about death, we were chatting about that earlier, and the best way to bridge that, but there's a certain lack of sensibility with not doing that, by the way, but I won't go there right now. I'll say as follows, that we have case law that's, I think, somewhat concerning to planners in Canada. It can be used. So at times we do go to jurisdictions outside of Canada that does not have this Statute of Elizabeth, which effectively is the Fraudulent Conveyances Act, which goes back to the 1600s. So as an example, we sometimes set up trusts in Wyoming, in Nebraska, in Barbados. And, you know, these are asset protection jurisdictions that do not have the legislation nor the case law, where we can hold shares of a company post an estate freeze and have the value grow there. Well, first of all, you know, since as an example, if you're in the province of, say, Ontario or British Columbia, well, you may be thinking to yourself, well, that's okay. We have reciprocal enforcement on Commonwealth jurisdictions. And we'll go to that Commonwealth jurisdiction with an order from a court in Ontario and ask them to relinquish those assets or to otherwise provide some of the value. Well, first of all, we never send any value in those jurisdictions. It all stays here. We have the future growth which accrues there. And of course, as an example, Barbados has no jurisdiction. The courts in Barbados have no jurisdiction whatsoever to make an award for assets that are not located outside of the country. So shares of a company back in Ontario or British Columbia, there's zero that can be done in order to enforce that order. So I'm just saying there's a lot of different tools available to you, and nothing's perfect, by the way, nothing's 100%. But in reality, what it does is it gives another layer of assurance. But that remedy would not be possible, as far as I know. But not to say that other remedies can't be used. Always vulnerability, always being susceptible to the unknown. So I wanted just to kind of share that possibility with you as well. So having said that, maybe we'll move along here and we'll talk a little bit about the 4 different types of planning that, you know, might be considered. And I'll just share our screen with you. And essentially, we're looking at a couple of different issues here. And one of them is an estate freeze. And of course, we know that estate freezes are very common. But before we get into that, Ian, I'd just like to ask you your thoughts on this. So an individual attends the office of an estate lawyer with the intent of coming up with a fashion of being able to, a process, being able to commute these assets to the next generation, to transfer in a tax effective way. So I guess one of the things that comes to mind is, you know, how likely is it that some of those assets can be transferred before a person dies? So there's 2 concepts there. One is a simple estate freeze, where essentially we're freezing the interest that an individual holds in a company, just to make it very clear. And the future growth goes to, you know, say the next generation, either through a trust or otherwise. The second is what we've listed here as Bill C-208 planning. And we know that the legislature has prejudiced family businesses for decades. And recently, Bill C-208 has provided for the capability to be able to pass on company to the next generation and claim capital gains exemptions and so on. So I guess I'm just wondering from an, you know, estate planning point of view, you know, how much sensibility would there be if someone's attending to talk about what happens after they die, also including the discussion, what happens before you die? Just your thoughts on that, if you don't mind, Ian.
Sure. And again, this is again, I always, when I have these discussions with my clients, I start with, be ready to, whatever structure you do, and you will typically set it up tightly and keeping control as best you can with the head or the heads of the family. But whatever structure you enter into, you are going to lose some control. There are going to be some corporate remedies that will be available in an estate freeze, for example. You would set up where the founder would say, listen, I've got enough. And you say, well, okay, if you've got enough, let's talk about how we can structure this in a way that the growth will go to your next generation. In so doing, you'll keep control, but you'll pass the growth on. But still, you do pass it on, and typically either in the form of a trust structure or in the form of directly to the benefit to the adult children. And they'll have some corporate remedies, but typically not strong remedies. And that sort of structure is so important, and it can be done in a way that is not overly burdensome, both from a professional fee standpoint, but also from really doesn't change your structure from a day-to-day operational standpoint. And that's it's an important tool. Bill C-208, which you'll talk about, that planning also gives you that same idea. When a family gets to the point where one of the generations has got enough, what's the best way to do it? Well, now's the time to do it. Why would you wait? Because you're just going to accelerate, you're going to increase your tax obligation. And if you don't have it well funded at the backside with insurance or cash or assets, you're going to just create new problems for the next generation. So the freeze is really, and it's, as you know, there's only a handful of tools left. The Canadian government has wrapped us up pretty tightly in terms of what planning options you have. And the freeze still continues to be one of the best options to consider when you've got to a point where you have enough.
Yeah, perfect. No, I think that's really important. And I think the tendency in some cases, if you're a lawyer that prepares wills in general, it may be something that you would think would be completely outside of your practice area to consider this. But if you step back from that position and think about what Ian just said, and that is that there are options that can be done, it essentially is consistent and harmonious with the reason that your clients are there to begin with. Another thing I'd suggest is if you're completing a will questionnaire, it gives you the opportunity to be able to bridge certain gaps. In other words, for the type of client who doesn't want to talk about dying, who obviously cares for their family, their children, their grandchildren are all very important to them. And but all of a sudden, when it comes to talking about dying, they're saying, well, it's not something I necessarily want to think about. Well, the reality is that on death, our assets are deemed to be disposed of, and tax is paid on capital gains taxes. By completing a will questionnaire, it causes people to, like it or not, think about it and talk about it. And I think that's the first step. So I'll ask you, Ian, as far as your view of the pitfalls from an estate planning point of view of not engaging a client in an uncomfortable conversation, just since that's something they will prefer never to discuss. And if they do, it's a yes or no answer. What do you do about that? How do you suggest our audience deals with clients who have that problem, or clients who are listening here today that have that problem?
Well, look, it's a really tough one. And it's one of those things that, when I was a young lawyer, one of the hardest parts of doing a will was trying to get through young couples that were trying to decide on who would be the guardian of the children. Right. And it was a stumbling block. And it was like, well, we can't do the will. Come on, and it was like the couple would go away and they'd have a lot of discussions about it. And it would sometimes bog down the process. Well, it's the same. It's the same with just getting people in the room sometimes with that. And part of it is this. I say to them two things. I say, one is you're most concerned with, you've spent your life properly tax planning, not evading tax, but properly tax planning, running your life in a way that was tax efficient. But what you're going to do is you're going to leave a ledger on your estate planning that says unknown amount, and it will be typically not in the tens of thousands, but it could be in the hundreds of thousands for litigation lawyers that you've never met and will never know. So do we really want to leave ourselves open to that kind of exposure if you haven't tied up your estate plan as best you can? And then the second thing I'll say to them is you're going to leave an emotional legacy that is potentially chaos? And is that the emotional legacy you want to leave? Those two things tend to get their attention. Nobody wants to, I mean, I find even, and I'm sure you found it too, even very rich people do not like paying professionals. It's at the end of the day, if they can do it, they will. But I mean, if it's at the end of the day, if they can organize their affairs through careful planning, proper communication with their family, and avoiding unnecessary expenses, that's music to their ears and typically gets their attention. But I'll also make sure they understand if they don't do it, they leave a gap and a potential emotional legacy that could be tragic for the family.
Yeah, perfect. Okay, so what I'll do here, we'll just spend a few minutes talking about some structures that exist and what can be done. And as we do, this will not be an in-depth tax discussion. It'll more be designed to make advisors aware of certain sensitivities. So I'm going to share this screen with you. Somehow it's not loading properly. Okay. One of the things that I'd like to start off with, and maybe we'll just take a little step back here in our discussion, because we've talked a lot about trusts. And, one of the things that I think we'd be remiss in doing is not just explaining a little bit more about what constitutes a trust. And of course, a trust will typically have three parties. It'll have a settlor who would essentially make a modest contribution in order to settle the trust. We have trustees and we have beneficiaries. And in the context of a domestic trust here in Canada, typically, I would say that the parents are generally the trustees. Now, before we go further, Allison, I would just like to get your view if you have a trust where you say both of the parents are trustees and so on. From a family law point of view, we talked about spouses being shareholders, but they give advice and we follow their advice. It's up to us to point out the risks. But what would your advice be as far as having both parties as trustees who potentially may not be easy to remove? What is your thinking on that one?
That too can be messy. How would the court deal with that? I think the question that a court would ask is, are they able to continue to make decisions that are in the best interests of the beneficiaries in their fiduciary role as trustees?
And also spouses, spouses as beneficiaries in some instances can be a problem. I'm thinking of the attribution rules in 74.4 of the Income Tax Act that can be applied, I should say, in a broader way, to say that having a spouse as a beneficiary, unless the company is the shares are CCPC shares, Canadian Controlled Private Corporation shares, it could be problematic as well. So again, we just want you to be aware of that. We're here to answer the questions, both today and in the future, if you have questions on this. So we'd like you to tread carefully in these areas. In some instances, we use protectors for trust as well, which can be used in order to ensure that the trustees were to act in the appropriate fashion that best represents the needs of the beneficiaries. So that's just a nuance there. As far as trusts are concerned, well, there's a number of trusts that can be used. In some situations, we've been talking a lot about asset protection. Well, there's other reasons for using trusts. You can certainly distribute income splitting, subject to TOSI rules. You can provide for the intergenerational tax efficient transfer of wealth. You can do rollouts of trusts, all completely tax-free. All of these things can be done. There's trusts that are intended for disabled children. Maybe Ian would like to talk about trusts that can assist for a disabled child as an example.
Sure. I mean, there's two sort of streams of that. One is, of course, the legislative stream that disability trusts and so forth that are available to families, but they also we have Henson trusts, which is arose out of Supreme Court of Canada decision many years ago, which allows for fully discretionary trusts to ensure that the disabled child maintains their benefits, but at the same time can enjoy some, and I say some because there are restrictions, some benefits from an outside inter vivos trust through the Henson Trust structures.
Excellent, excellent. So we'll move on a little bit here, and we'll just say, we've talked a lot about the beneficiaries. Well, certainly the trustees have a duty to the beneficiaries to ensure that they're acting in the best way, but in some cases they may not, which is another possibility too. So that's something we want to point out. We have all sorts of different issues there. Trusts can be used to insulate against U.S. estate taxes for U.S. vacation property. Certainly they can be used to provide for minor children through a family law matter. They can be used, as previously mentioned, to provide for distribution of income and so on to children after death. So there's many different ways, but there are certain regulations and issues there that we like you to be aware of. But we have a situation here that Allison was referring to previously. We have a couple, Bill and Carol, and of course, Bill and Carol have a successful business. They have an operating company, and underneath the operating company, underneath the holding company, they not only have the operating company, which has about 10 million of cash. It has real estate, it has some life insurance, but it also has another corporation that held a multi-residential real estate, an apartment building in the GTA as an example, that they recently sold for 50 million in cash, and that money staying inside of the company. Now, there's a certain tax-driven reasons that Ian mentioned earlier that you are aware of, undoubtedly, or if you're not, we'll talk about that. But in general, there is certainly problems by having commingling non-active assets with active assets. And it may be that there could be a significant loss by not having capital gains exemptions available to the shareholders upon the death of Bill and Carol, simply because there's zero chance, in all likelihood, there'd be zero chance, that the shares of this holding company would be eligible for the capital gains exemption. Therefore, there's a need to purify, there's a need to separate the operating company from the multi-residential company out from underneath the holdco. So there's many things that can be done, but when we do that, it's often the case that we would then place that under a different holding company. And when we start moving cash around or moving around companies, it can become a hotbed for disaster, both from a estate planning point of view and also from a family law point of view. In this particular case, we have one child whose name's Ethan, that Allison referred to previously, who has the skills and the capability to take over the company. The other children would like to have the company, but it's the view of the parents that they do not have the maturity, the business skills, the level of leadership ability and all of those things that's necessary for that to happen. So we're going to paint a picture that we will end up eventually in a litigation matter involving Ethan and his siblings. So there's something for you to put in the back of your mind as we go through the rest of this. The other thing that's going to happen is we're going to cause Ethan to become disgruntled with his marital arrangement. He'll end up separating from his wife. And of course, you'll see in a few minutes that we've used a trust for this, and we've used a trust and we've made Ethan a beneficiary of the trust. And all sorts of other problems might just come about through the process. We've also attempted to reduce capital gains taxes because there's about $50 million over here that's in cash right now. And upon the death of Bill and Carol, well, certainly that amount will have to be paid, but I'll just go through a couple of scenarios. Well, one of the things that I mentioned previously is we'd set up another holding company. So we have holding company 2 on the right side of the screen. And of course, what we've really done here is through a series of complicated transactions known as a single wing butterfly or related party butterfly, we were able to essentially shift that operating company out from under Holdco 1. So now we have 2 silos. Typically in that situation, we may or may not amalgamate afterward, but essentially we were able to achieve that structure for them. And from there, I'm not sure if how many of you used Lego blocks as children, but that's really what this is about. And how you assemble those Lego blocks in this context can have catastrophic consequences later on. And we're here to help you try to avoid some of those pitfalls. So that's essentially what can happen. The problem is you might have different shareholders, and Holdco 2 is Holdco 1. This would be our structure. The other thing we would do is we have 10 million in OpCo. We'd set up a sister company. We call it Cisco because it has the same parents as the operating company. And essentially what we would do is we would usually through a stock dividend, we'd provide shares to Bill and Carol. We'd have them issued, have those shares issued to Cisco. We'd do an 85 rollover of those shares, and Bill and Carol would take back the shares. We'd later redeem them for cash. No tax. We've completely divided the two, completely separated it. But who is the new recipient of the 10 million? How is it going to affect Ethan? Well, maybe in the mind of the parents, it could be that Ethan is already getting the active business and he doesn't need the 10 million. Maybe more to your point, Ian, it would be really good to be implicit in explaining why Ethan's not getting that $10 million. Now, what might be a bigger concern is the 50 million later on down the road. But essentially what we do here is we do a simple estate freeze by really saying we're going to take the shares. And if you, I know this looks a bit complicated, but we have an OpCo and HoldCo right here. And for those of you who are in the habit, if you're a business owner, of glossing over, please do not. Please zone in on this, because we need you to fully understand the implications in order for what's important for you to be carried out efficiently in your business and in your lives. So what we're really talking about here is doing a few things. So we call this a butterfly. We take the 50 million and we butterfly it into Cisco. We take the real estate that exists, we butterfly it into Invesco. We then look at pushing money up tax-free through an intercorporate dividend from OpCo to HoldCo, flows through the trust and can be distributed to these companies. Again, the problem is you may have different shareholders. When we do these kinds of butterflies, they anticipate related parties. And in effect, what we're really saying here is that we're ensuring that this stays within the family. It's not done in contemplation of a sale or anything else. The other thing we've done, and I'm just going to open the floor for comments momentarily, is we've said, well, look, we'd like to take advantage of Bill C-208, but the issue is as follows. There may or may not be, well, in this case, we have cash available, but say there was no cash available to buy those shares. Well, very simply, we could set up a holding company for Ethan, and we could have the trust essentially issue a promissory note. We could have Ethan Co. issue a promissory note to his mother and father to buy the shares. Mother and father claim the capital gains exemption if it's available. In this case, it would not be, as I mentioned, because you have all of the shares tainted because of non-active assets. You know, and this brings me to another point. I don't mean to deviate, but I was at the Ontario Bar Association speaking to a group of estate lawyers. And one of the questions I asked the lawyers, I said, do you look under the shares when you are preparing wills and there's corporations involved? And one young lawyer put up his hand, he says, what do you mean by looking under the shares? And of course, I said, well, to the extent that you're hopeful that you can transfer these assets tax effectively, have you considered eligibility for the qualified small business corporation? And of course, no. Should I? Well, I think it's critical because of the fact that the law says that all or substantially all of the assets of a corporation must be actively used in the business. Otherwise, there is no capital gains exemption. A butterfly strategy or other purification methods. Now, this is a purification method. The problem we have with it as planners is that if we're able to push money tax-free from OpCo to HoldCo through the trust and back down to any of these beneficiaries, even the one over here, the problem we suddenly have is again, really who is it going to affect and how is it going to affect them? So we have all of these issues over here. So one of the things that we'll do, we'll go back to the Ethan Co. Ethan Co. will buy the shares from the parents. So essentially this will become a new holdco. And if there's no cash available at that moment, there'll be a promissory note used to buy the shares. And then over time, the dividends are pushed up through the family trust over to Ethan Co. Ethan Co. would then have the cash available to satisfy the promissory note. Okay. The other thing we're doing over here at the bottom, we have a multi-residential real estate holding company. Well, at the death, if there's no estate freeze there, there's going to be capital gains tax, but in addition, there's secondary tax. There's a dividend tax that has to be paid. So essentially what we do is we have the estate take the shares of that company, it does a rollover to a new company in exchange for preferred shares and $50 million promissory note. And of course, later, we would probably amalgamate the companies and we pay out the 50 million without any dividend tax. So this is, we refer to this as a pipeline structure. So again, it really depends on, who amongst the beneficiaries are going to be affected by that. And being able to, you cannot have the tax tail wagging the dog, is what I really like to say to you. All of this planning may be the worst thing in the world for you to think about doing, or the best thing in the world for you to do. It really comes down to identifying your objectives, identifying what's important to you, and then being able to navigate. And there is no simple solution. Every situation is completely different. So at this point, I'd like to open the floor for Ian and Allison to comment on the efficacy of this and what potential problems they may see that could come about through this kind of planning. Just for the education of all of us to be able to fully understand what are the consequences of doing things in different ways, not badly, but in different ways.
Sure. Well, I mean, go ahead, Allison, if you want to start from the family law perspective, or I can, whatever's easier.
Go ahead, Ian, that's fine.
So I see a couple of things here, and this is, as you say, it looks more complicated than it really is. It's a fairly straightforward, on the right-hand side anyway, fairly straightforward structure that's arranged in the estate freeze scenarios. Obviously, careful consideration on the family trust level. Are we going to have, is that going to be a discretionary trust? And who are the trustees? Is vital consideration there. And also the funding of the life insurance to make sure that is indeed funded. And I know Allison will talk about that, because on the family law side, you find that all of these structures that include insurance sometimes aren't properly funded or are acted on. And the other side of the page, I would just say this, that, from my standpoint, this is where it does get a little more complicated, and I want to make sure that I've had a good visual discussion with my client to make sure they understand where the structure goes next. As you say, it could be amalgamated, it could not be, but where's this going to ultimately end up at, and who's going to be ultimately the beneficiaries, and who are going to be ultimately be the controlling aspects of it, and showing in this puzzle where the control has been given up, both at the family's trust structure level and at the corporate level, on the shareholder level too, so that the client understands that to do this, although it's got tremendous advantages, it's got some disadvantages in terms of who may come at the head of the family, and on what basis the tax may come.
Excellent. Thank you, Ian.
So if Ethan turns out to be in the case study a replacement trustee and is one as well of the discretionary beneficiaries, then that could extend that could fall under the definition of property, which would apply. So certainly while Bill and Carol are still alive, the court would not order Ethan to distribute the significant assets of the trust to his spouse, because there's the other siblings as beneficiaries. Now, if Ethan may outlive his parents, Bill and Carol, and he's got a vested interest subject then to divestment if he doesn't survive his parents, Bill and Carol. The question is, how do you value that for net family property purposes, to calculate an equalization payment under the Family Law Act? Well, it certainly would be a fun actuarial exercise, including, I believe, what is the likelihood that Ethan will outlive both of his parents, and the valuation piece would be most interesting.
Excellent, excellent. Okay, I just saw a couple of, I guess, concluding comments I'll make, and that is, this whole issue of control is one that I think is very important. We've all heard of cases where estate freezes have been affected, which have caused the loss of control for the shareholders. And typically there's, as Ian mentioned there's certain remedies that can be put in place. As an example, voting control, having the shares that have voting control. And of course, we oftentimes would, set up shares that are, have, say, more votes per share. We call them Class V shares. The important thing is that doing nothing whatsoever is very costly. If you have a company that's likely to grow in value. And I think planning is important, at least to consider what the best option is and should be. So I noticed that we're out of time. We've just gone past 1 o'clock. We always like to keep with our time our timing on these matters. I will mention that our next webinar will be dealing with alternative finance structures over $50 million, dealing with climate bonds, green bonds, sustainability bonds, and funding projects. I think you might find this interesting if you're a lawyer or accountant and you have clients that have projects that are requiring capital. This is something that the cost of capital is at really an incredibly low level based on today's interest rate climate, either in any event. So I've noticed there's a couple of questions over here. And there's a question, would a trust settled in Ontario cause any US implications? Well, it certainly would. And that whole subject can be done. There's usually either a US trust or there's a double tier limited partnership, limited partnership structure that can be used in that regard. But that subject we won't have time to really go into, but at a later point, please feel free to give us send off a note on that one or a call, it's fine. Well, 85 rollover, past CRA review with a promissory note. Well, in this particular case, this is not a promissory note used for an 85 rollover, it's to purchase shares. So we're not stating that it would. Use of trusts and association of all companies. I don't know that I understand that question. So maybe Ian, you'd like to take a run at that one. Do you think that a family trust is always a good solution, or would you say not always?
Oh yeah, fair comment. I mean, that's a good question because, at the end of the day, the family trust is just one option. Corporate structure of passing on the wealth is also a totally viable option, and one that, you see in family held operations. You don't want to put it into a trust structure. You want to put it into the hands of the next generation directly, whether they want to someday down the road with their own children do that. But if you've got a mature situation where you've got mature leadership in the family and in the corporation and in the existing opco, there's sometimes no good reason to create a trust. And in fact, a trust only does is create an extra bureaucracy. So I always want to make sure I've thought through whether or not, because remember also, trust with these structures, losing the control, but trusters are also a bit of, as we used to say, ruling from the grave. I mean, sometimes it's better just to give up the power, give up the structure, give up the control, because that's the only way you're going to mature the next generation to take on the full responsibility.
Excellent comments.
There are a few good questions also in the answered tab.
Oh, I did. Can you read them, Jordan? I can't see them.
Attendee asked for a discretionary trust. Should you wait until after the marriage to list someone as a beneficiary? Is there an obligation to disclose that you have now named a beneficiary? Do you have to disclose the value if it is a discretionary trust? And is there a specific period of time that you should wait until after the marriage?
Allison, do you want to handle that one?
So in terms, good question, questions, in terms of timing, much better to gift an interest in a trust after that, let's say, adult child's marriage. Much better. Is there a certain amount of time after? Not that I know of. Would you want to do it the day after? You might want to wait a bit. But that is, in my mind, as a family lawyer, most important. In order that that adult child, should they separate down the road, be able to claim an exclusion of that interest in the trust.
Okay. Jordan, do we have more questions, or is that all?
One of them was asking, do TOSI rules still apply in a breakup?
Well, that is a complicated answer. The TOSI rules, I was an expert on it once upon a time, but they've become so difficult in trying to ascertain. That's a very good question, but typically they would deal with any company that's a Canadian-controlled private corporation that would have that would have family members. And you're saying if the person remained after they were no longer, I would say they would be deemed to be related for the purposes of the act, is my guess, but I'm not saying that unequivocally.
And there was one last question, just more commenting on asking whether or not there's how you would determine value of one's interest in a discretionary trust, if it's considered property for family law purposes.
Yeah, I mean, the question I think is first of all, do they have an entitlement? And since the trust is purely discretionary, their entitlement may be all, part, or none. And that is, and I think if you're talking about in the context of either a state law dispute or a family law dispute, whether or not the assets, those trusts, and Allison had mentioned previously, whether there was an entitlement to those assets, and not so much whether they would be portioned from the trust, but whether the same value would be commuted. How would do you want to approach that, either Allison or Ian?
Yes, looking at some of the case law as well, and some of the things I've worked on too. That is a threshold issue. However, that typically either parties are going to, and over the last several years, it appears that spouses have been settling, so things have not gone to trial. But in terms of the trier of fact, if parties don't settle, the issue of equalization of net family properties and what is to be included in that definition of property, and it goes to trial, then for the judge, the trial judge, to make a decision on that issue, on whether the interest in the trust is properly included under in property, and then of course you've got to line things up in terms of what would an interest be valued at, and of course in terms of valuing an interest in a trust, I mentioned a piece of that pie, which is the actuarial exercise at times, and it could we also often get involved experienced certified business valuators who are accountants as well, and it can be quite complex, not at times an easy exercise.
Right. Ian, would you like to make a concluding comment about?
Sure. Just on that point, there's sort of two streams of the law on how the value trusts it appears. One sort of looks at it. There's a case called Sega where they sort of looked at how many beneficiaries they were. They tried to value it on that basis. And then the other is the Tremblay decision, as Allison says, looks at control. Valuation of trust is it's an untested area in some respects, and one that I think over the next 5 to 10 years, we're going to see a lot of new judicial sort of pronouncements on.
Excellent. Well, we'd like to thank everyone in attendance for supporting our program, and a special thank you to Ian and Allison for participating today.
Pleasure is ours.
A pleasure.
Thank you. Take care.
Thanks a lot.
Take care.